afternoon. Hello, everybody. I want to call to order the Planning Commission meeting for September 18th, 2008. We have...
Paula will be back in a minute.
Paula will be back in a minute, so we do have a quorum. Her drink is here, so we know.
Printing up some stuff last minute.
Yes. For the public hearing, I would like everybody there's a piece of paper going around. If you can please sign it. If you are thinking about testifying, please sign it. There's also, on that same piece of paper, just sign it at the bottom if you're just here, because we also want to know everybody who was here. I'd like to administer the oath, so everybody who's going to speak today, please stand up.
Do you swear or affirm everything you say will be true?
I affirm that everything I say today will be the truth. Okay. I want to change the agenda a tiny bit today. We have a public hearing set for the first item on the agenda, and I would like actually to put that down under after communications. We have no cases today, right?
Yeah, but we have at least
We have one.
3 different communications. Actually.
Right, we have
no
one.
Cases.
No cases, so we can skip that one. Communications, we have an amendment to the communications. We have one more in it, and we have these other 2 communications. I'd like to do those first.
I think you actually have to move to change the agenda.
Okay, I'm saying how I want to change it. Okay, so I would like to do that so the people who are here who aren't going to testify but have business can go and say what they need to say and then leave. Does that make sense for
So
people?
why wouldn't we have the public hearing first? They're all here and ready.
Because I think that the cases will go quicker.
I don't think so.
Okay, okay, then let's go the way of the agenda. The movement has been soundly defeated. That's fine. I tried. Okay, first on the agenda is the public hearing for the proposed amendment for the proposed ordinance.
Pass this out. And you get one too.
Of the council, to give some history, council passed this ordinance to us. To look at, and in our discussions that we've gone over for the last few months, we've had a lot of back and forth about how it should be worded, what sort of businesses should be covered and such. We've got feedback from people already, and that's why some of the wording has been proposed to be changed on it. And so what we're trying to determine from this public hearing is how businesses feel, how neighbors feel about the proposed changing of the operating hours for businesses in B3 and B2D, because there's some issue. We had a lot of input from businesses that it shouldn't be B2D, that it should be B3, and it shouldn't be B3, it should be B2D. So we need to have discussion about that and public input about that. So any comments from? Yeah.
Okay, the public hearing covered the, let me read it in its totality there. Athens City Planning Commission will hold a public hearing Thursday, September 18th, 12 o'clock, third floor chambers, City Hall. Purpose of this meeting is to receive public input concerning Resolution R0308 regarding amendment of zoning code, section 230407A3, eating and drinking establishments within the B3 zone. The Commission will receive input regarding their proposed amendment, adding section 230406B. The proposed change would affect outside business operations near residential zones within the city of Athens in the B2D zone. So that's what the public notice was about. The proposed resolution, just for the record, is section 230406B that we're proposing, eating and drinking entertaining establishments. The principal building residing in the B2D zone is identified by the Athens zoning code, and business conducting outside operations shall cease outside operations at 12 a.m. on Friday and Saturday, and at 10 p.m. on each day, Sunday through Thursday. Outside operations shall be defined as any service or consumption of food or drinks that occur outside the principal building of the establishment. Do you want to read the letters into the record? You should have two of them, I believe.
I have Aaron's.
Okay, and then there's one from Mrs. Claudia Gonzalez Viejo. This one right here, if you don't have it. It's in bold,
Okay.
so that should be noticeable.
So we've, do I read? I'm new at this, okay? So this is my first public meeting, my first public hearing. Do I just say that there's letters?
We could note it, but I'm sure it should be read into record or submitted to record, your choice.
Well, they're awfully long, so I think we should submit them into record.
Okay, but,
Okay.
okay, your choice.
Well, I mean, the pros and cons, so. I would submit them into record because they are both really long. So we have two letters that will go into record. Yes?
You'd rather have it read into the record?
I think that because they are long, there's a lot of opinion that's being expressed, and everyone should be privy to that at this point.
Okay.
Okay, I guess that's fair. Okay.
So, and not only that, it might be saving some redundancy that occurs within the meeting. Do you want me to do one and you do one?
I'll do it. Okay. It says, this is from Aaron Leatherwood, who doesn't give his address. Oh, okay. Christine, I am unable to make the Thursday meeting, but I would appreciate if you could print out my input and provide it to the Planning Commission. I'm assuming this is Christine Miles. Okay. Alternately, if the Planning Commission has my email, I would be happy to send my comments directly to them. My thoughts in this matter are some history background. It's my understanding that Bronies is opposing this ordinance. However, when Bronies was first established, they did not propose an outside patio as part of their business. It's entirely possible that they would have been denied a liquor permit for this location if they had proposed an outside drinking patio, as their business close to a residential neighborhood and several churches. Bronies then abolished their outdoor parking to build an outdoor patio, in clear violation of city code. Under considerable pressure from the Athens City Prosecutor, Bronies reestablished their parking, but without marking the spaces as they are zoned, such that the cars which use their business always park perpendicular to the actual spaces, creating a situation where larger vehicles block the sidewalk. In our tolerant and pragmatic and uniquely Athenian manner, this has been addressed by posting a sign asking cars not to block the sideway, a solution which half works. Of course, a perhaps more workable solution would be to label the spaces as compact parking only, but this would raise a host of new issues. Would 3 spaces for regular cars, which are used to park 5 compact cars, count as 3 parking spaces or 5 for purposes of city code? This is all a bit off topic, except the mention that Bronies has a history of ignoring the law when it is convenient, and to suggest that their preference in this matter, which again relates to their outside patios, should be not merit special consideration on behalf of the Planning Commission. Enforcement. If the Athens City Code was enforceable as is, none of this would be an issue, because we wouldn't have a noise problem. However, the Athens Police Department has, in the past, testified that they will not issue noise violation citations where outdoor bar patios are concerned. The Athens Police Department has pointed out that the noise from any single person may not violate the ordinance, and that while the patio might collectively be well in excess of the noise ordinance limit, they are not going to issue citations for an entire patio full of people. If we accept that we have no way of controlling the noise volume of a large group of people late at night, then we need to look at other solutions to the noise problem, such as moving people inside. The ordinance proposed by Athens City Council should be enforceable in this respect. 3. Many people in Athens have stated that they would like Athens to be more outside eating. They would like Athens to have more outside eating spaces. And perhaps the city of Athens has an opportunity to encourage this. Specifically, the city might look at regulations which are more permissive towards outside eating establishment during the day. The city should recognize that most of the noise problems after 10 p.m. on weekdays and after midnight on weekends are alcohol-related. The patrons of establishments which serve alcohol are often rowdy, and it is accordingly reasonable for the city to request that the patrons of these establishments might move indoors after 3 hours. Of course, this opens the question of restaurants which serve wine and how to differentiate a quiet restaurant from a noisy bar, but few restaurants are open past 10 p.m. And a reasonable compromise might be to allow people to remain on outdoor patios after 10 p.m. or midnight on the weekends, provided that this establishment stops serving alcohol after these hours. as this would allow restaurant patrons to continue eating on outside patios after hours. What kind of community does Athens want to be? We are a community, a diverse collection of students and parents and families of people and experiences and opportunities. And with all of this, we should all be seeking balance and tolerance. I believe that the ordinance proposed by the City Council helps us do this. Aaron Leatherwood. So, will you read?
I'll read the other one?
Yes, please.
Okay. Because it is long, I
It is
understand. This one is from an essay, Claudia Gonzalez Viejo. We received this September 17th. To the Athens Planning Commission, I understand the following resolution will be on the table for decision. Section 230407, eating and drinking establishments. Principal building shall be at least 200 feet from any R1 or R2 zone. Business conducting outside operations within 200 feet of a residential zone shall cease outside operations at 12 a.m. on Friday and Saturday, 10 p.m. on each day, Monday through Thursday. I would like to express my great concern with this rule that would potentially limit and handicap the already existing fragile business community of downtown Athens. First of all, although I am sympathetic to the problems the residents who live near students and establishments that the students face, I don't believe that we have the right to limit normal activities of businesses such as restaurants in order to accommodate a few individuals. The limit of 200 feet is simply arbitrary. Why should my neighborhood be protected from noise if I'm 250 feet away or 500 feet? Clearly, the 200 feet is a proximity measure, however. As residents, I had a choice to be in that proximity or not of any establishment, thus limiting now what businesses can or cannot do because my proximity choice strikes me as very unreasonable. Second, the business community in Athens is trying very hard to improve the fragile economic growth by attracting tourists to our unique eating facilities, art venues, and small artsy stores. How would a rule that shuts down nice outdoor eating affect such efforts? It goes against any notion of an interesting restaurant experience that most people from out of town are familiar with and would expect to receive. To place this in context, how would Eastern Columbus, which is very near residents, or the short North District in Columbus, look with a rule like the proposed one? Please visit, basically gives us website, www.shortnorth.org, to see a good example of a nice marriage of eateries, bars, art galleries, shops, and residential properties. This is what many in Athens would hope for our community. Third and last, even if this rule was a good idea, the enforcement of such arbitrary measures would end up being a nightmare to enforce. Given the geographic location of many student residents nearby uptown and in the neighborhoods in question, this ruling would result in more, perhaps even louder, house parties. In the long run, no interesting eating facility or restaurant would likely locate in Athens, further decreasing the attraction of our town and negatively, in fact, impacting our economy. Sincerely, Claudia Gonzalez Viejo, excuse me, PhD. And again, this is probably in response to the 0303 R0308 resolution from council.
Okay. Where's our sheet that went around? Who has what sheet? Okay. Do you want to? Okay. So we'll just start with going down the list. I'm going to limit to 3 minutes. Okay. I hate to do this, but we have a lot of people, and if you feel that that's a burden, just remember if somebody said something a couple times before, you can say, I agree with this person, and then add a new thing, and that will help the discussion so that we can get everybody's point of view. Okay. So the first person on the thing is Lance. You're not wanting to? Okay. Not on this one, on the other one. Okay. Let's see. Jim Skillery? The podium?
Podium?
Is this for the public hearing?
Yes.
Okay.
My name is Jim Sillery. I live at 36 Fairview Avenue. I've lived there about 18 years. That's why I take a little bit of offense when somebody suggests that I choose to live in a student neighborhood. When I moved up there 18 years ago, and certainly when I moved on Highland Avenue 34 years ago, there were no student neighborhoods. And so I've chose to live in a family neighborhood. And I'm going to start with a letter that I wrote to a former mayor to really demonstrate my point. It's a letter written August 29th, 1984, to Mayor Edward Beckett. I don't know how many of you all were in town even at that time. Dear Mayor Beckett, as you know, I've been on the Zoning Board of Appeals for several years. During that time, I've received numerous inquiries concerning group families. They were defined at that time as not more than 3 persons, not related by blood, marriage, or adoption, living together as a housekeeping unit in R1 areas. In other words, an owner may rent his house in an R1 area to 3 individuals who are not related by blood. This appears to me to be contrary to the purpose of the zoning code. The lifestyle of those families who choose to live in an R1 neighborhood is, more oftentimes than not, much different from the lifestyle of these so-called group families. I would propose that the Planning Commission consider amending the code to forbid non-owner occupied group families in R1 and perhaps even in R2 zones. This would be a strong step in preserving these neighborhoods. I wrote a similar letter to the President of Council. I got no response to either letter, and of course we know what the history has been since 1984. It was time then for planning, and unfortunately the planning didn't occur. 10 years ago, Courtside Pizza didn't exist in its location. 4 or 5 years ago, I think, even Brony's wasn't there. A year ago, Palmer Place wasn't there. It's time for planning. And I certainly appreciate that at least on this occasion we have the opportunity for the discussion. This proposed ordinance is based upon 2 simple premises. First, a person has the right to live peaceably in his own home. And secondly, the activities of one property owner should not infringe upon the peaceable enjoyment of another property owner. The outdoor operations of eating and drinking establishment after the times proposed in the ordinance, and frankly, in my judgment, even before some of those times, is incompatible.
I'll give you 10 more seconds. Just finish. I'm sorry.
I've got about
Okay.
5 more minutes, but
Well-
it's incompatible with that. The next point I want to make is Stimson Avenue is all zoned commercial. We're not looking at the places that are there now only. We need to look at what's going to happen to Family Dollar, to those adjacent lots, to all the way down. There's corner of Cornwell and Stimson, 3 residences being marketed as commercial. Every residential owner on Stimson Avenue would be very happy to choose commercial. Then what's going to happen then with Morris Avenue and Ohio Avenue and that? I've got many, many arguments and many responses, but hopefully you'll give me the opportunity at some time. Thanks.
Okay, great, thank you. I would also encourage that if you feel that you haven't made your point well enough, because it is a short amount of time, or you want to make further points after listening to people, feel free to write or email us. Our email is on the website, or we can write it down someplace, not in this building. And so that we will also take written testimony. So, okay. Let's see. Christine Miles?
Thanks for allowing me to speak.
Sorry.
That was really fast.
She's new at working at that.
I know, I'm new.
Okay.
Is that right? Okay.
Okay, I'm on. First of all, I would like to concur with what Mr. Leatherwood had to say about the proposal from City Council being one that is a compromise, that is not everything that the residents would like, nor is it everything that the club establishments and restaurants would care for either. However, we are hopefully working in the Planning Commission and in the oversight of the city to produce an environment that is dimensional. I don't think any of us want to see an entirety of one thing or another. I'll cut this short. I would just like to say that I've been an Athens resident since 1968, and there have been astounding changes in the community, many of which have been to the detriment of the community base here, meaning the families who struggle to maintain their presence within neighborhoods that are established that make a small town what it is. The ability to walk to the schools, the ability to walk out your door and go uptown to enjoy the restaurants or the theater or what have you. However, if one is allowed to exclude the rights of the other, then we're moving in the wrong direction. I am not here just for myself. I would like to toot my horn here and say that by golly, I even designed the flag of this city. You know, it is near and dear to my heart and will remain so as a totality, not just as a venue for people who choose to be out late at night, which is great and fun and fine, but with respect to the other folks who live here as well. So that's what I would like to encourage you in thinking about making a strong recommendation to City Council to adopt this proposal. Thank you.
Okay. David Cornwell?
Hello, my name is David Cornwell. I am the owner of Courtside Pizza. And a couple of things I want to make a point of that Jim talked about the history of Court Street, and I remember as a child, this is back in the 70s and 80s, and looking at Court Street as a whole, if you looked at the north block of Court Street, it was nothing but vacant holes and businesses that basically didn't exist. So if you look at the last 10 years where Courtside has been put in, and Bronies, and there's numerous businesses down there that didn't exist before. So the development, in my opinion, has been nothing but positive, and Court Street as a whole has never looked better than it has now. So I'm trying to decide, hearing everything, is this a noise issue or is this a zoning issue? Because from a noise standpoint, one business, you can't point the finger every night and say that Bronies is making all this noise. And one thing that could happen with a shutdown at midnight, if Courtside and Bronies say, okay, all these patrons need to come, go inside Courtside or go inside Bronies, first of all, at midnight on a Friday and Saturday night, that's impossible. So these people have to be dispersed somewhere. So we can't take them inside. So they basically have to say, okay, thanks for coming, but you guys are kicked out. You need to go somewhere else. And chances are, when they go somewhere else, it's going to be not uptown, because by midnight, uptown bars are packed. And if anyone walks down Court Street at midnight on a Saturday or Friday night, you're probably not going to disperse 400 people or 300 people into other bars. So the majority of our customers, I can tell you, live on the north block of Court Street, Congress Street, Franklin, Grosvenor, Palmer Place. So if you want to shuttle 300-400 people out into house parties at midnight, I think it's just going to just make the noise issue even worse. So we do everything we can to control noise issues. We did surveys at Courtside the last 2 nights to find basically our customers, our tenants that live above Courtside and on our patio. And I had surveys, and I can show them a stack. I have 600-700 names that we did in 2 days, and half of them live in Corner Reynolds at 85 North Court. So they would be unhappy to see our patio get limited in operation. So I'm sure everyone else would too. So other than obviously the East Side group. So I'm sure people can add to that, but that's where I stand.
Are you David of David and Jenny? Because I did receive an email.
Correct.
Copied on an email.
Yep.
But do you feel like you said everything that you need?
I do, and
Okay.
I think we're going to back it up. So.
All right, thank you.
Let's see. Robert Satmary?
And
Yep, tell me if I pronounce your name wrong. Some of your writing I can't read.
Hey, my name's Bob Satmary. I'm from Obetti's, and I just wanted to say a couple things because, we're part of the situation. I think probably most importantly, well, I'm very excited that, these issues are being addressed, hopefully to everyone's benefit in the long term or short term. But my concern is that normally as a group of people, we tend to not think clearly or focused on the specific issue. And like it was already mentioned, I think that's really important for all of us is to focus on what is specifically the issue. If it's a noise problem, or is it dining outdoors, because these are things that need to be addressed. However, as indicated in the very first letter read, and I'm not sure if it's true or not, I see two specific issues here. One is the noise problem, and if there indeed is a refusal to enforce the noise ordinances by the organization in charge, and I think that's the problem. If people are making noise unruly and loud inappropriately, then they should be let it be known that they have to cease and desist, or they'll be fined. As far as outside dining, we have tables and chairs outside. We bring them earlier because we're on a sidewalk and late at night it does get messy. I will not deny that. But I do think that outdoor seating and dining is a separate issue from the noise issue, which needs to be addressed. However, I'm really excited about the dining issue being addressed too, because I envision also like a Short North, nice gallery stroll kind of place. But that may be hard to pull off in university wham bam at the end of the night. But I just hope that everyone tries to stay focused on exactly what the issue is and define that, which I think is a noise issue that should be enforced. That's, I think, all I have to say. Thanks.
Great, thank you. Let's see. Chris Pyle?
Hi, my name is Chris Pyle. I'm going to read because I'm bad at winging it. I like the David Bowie quote there. That was nice. I own Donkey Coffee, and I'm troubled with the direction that we're going with this issue. I'm disturbed with Bronies and their lack of responsibility that they're taking. It was troubling to read about this problem before it directly involved me, and now I'm upset because of the lack of responsibility that affects me. Donkey has been operating for 6 years with 6 tables outside, and generally we have about 20 to 24 customers from 10 o'clock at night until 1 a.m. in the morning. We're usually at capacity until 1 a.m., and our clientele are very quiet. They mostly study, they talk a little bit, and they make little noise at all. And they love those outside tables. And usually there's not enough seating inside, and that's partly why we have them outside as well, although it's really nice on nights that we've been having lately. There's actually much more noise that comes from our student neighborhoods across Congress than comes from our place, way worse. To my knowledge, we've never had a problem with noise because of our outside tables. Now, to make a law that will affect us and anyone else, because many of us have an issue with 1 or 2 businesses uptown that are right next to the residential neighborhood, that they're abusing this is not, I don't think it's good lawmaking, in my opinion. I'm confused as to why this has come to this. I don't think it's a good solution. I may not have all the facts, but it seems to me that opening an outdoor nighttime patio with drinking right next to a residential neighborhood without willing to go the extra mile to keep the noise down is simply poor judgment and falls very short of being a good neighbor. My opinion is that Bronies has not lived up to their civic responsibility by blatantly breaking the law night after night by not adhering to the already established noise ordinance. So I'm confused. If we have an ordinance in place already, shut them down. If you get another complaint, fine them. Move everyone in for good until they take steps to keep the noise down. My understanding is that the noise would drop considerably if there were a roll-down canopy above the outside tables. Being a sound person myself, that would be true. that would cut down considerably the noise, and it seems to me like that could be done. and I believe it's been proposed to them. Have Bronies take responsibility instead of making a law that affects an establishment like mine that has not had any good neighbor issues with this issue. I actually want to see more tables outside and more patios uptown. I love the European feel that it brings, and I think it's good for business, and I think it's good for our community. So can we please figure out what to do without punishing other businesses for lack of responsibility and poor judgment of another business? We look to you guys to make ordinance and laws that make sense and are fair. I don't believe that this would be fair, and I don't believe it makes sense. My business would be greatly affected by this law, as would others in future businesses that desire to have outside seating. So, real quick, please consider dealing with this issue directly with Bronies or provide some kind of variance for a business like Donkey that has not had any kind of problems with the community concerning noise levels at night. Thanks.
Thank you. Okay, let's see. Kim Goldsberry?
Madam Chairman, may I interrupt? I'd like to be sworn in so I can testify before I leave.
Okay, can you come and sign the,
Can you take that to him?
Yeah. Lance, you want to do that? Thanks.
okay. We'll go with Kim.
Do you want me to sign first or testify?
You
Well,
can sign first.
there's a list right there, so.
Yeah,
it just sounds-
you, and this is, no, it's just, this is concerning the noise ordinance. I'll swear you in when you get up to
Kim
the podium.
Goldsberry.
Okay.
Thank
Okay.
you for the interruption.
Okay.
I'm Kim Goldsberry, and I wrote a letter to the city council members, and I believe I copied the mayor on this in regard to the ordinance that's being addressed. And I was just going to read that today. I'm writing in regard to the issue before council discussing the North Court Street businesses and their patio areas. The Athens uptown businesses are doing a great job to improve the exterior, uniqueness, and business opportunities in the Athens area. The residents of Athens enjoy having a new and different opportunities for dining and socializing with friends, family, and business associates. We live at 1 North Hill Drive and have not had any issues to do with the noise bothering us or keeping us awake at night. My husband and I feel that there has not been any increased level in noise that can be contributed to the outdoor patio businesses alone. At our home, we live near a number of things that, we can hear a number of things that take place around town, Athens, including Ohio University Band practicing, the announcer during football games, the Athens County Fair, and other activities. Shutting down the patios and businesses that are making an effort to bring unique and different dining and socializing opportunities is not fair. If you go to the trouble of doing away with one outdoor activity, where is it going to end? Is it right to punish the one end of Court Street and not the other areas of town? All outdoor patio areas are near homes and neighborhoods, including Station Street, the Maplewood Tavern, and other businesses. Therefore, how can council rule against a few and not have equal treatment for all tax-paying businesses in the city of Athens? Closing the patios will be doing a disservice to several area business owners, residents, and visitors to our community. We know for a fact that out-of-town business executives and owners bring clients to Athens and visit one or two of these different patio areas that are being discussed. The success of these businesses is far more important to the success of Athens County than the complaint of a few neighbors. When purchasing our home, we recognized the advantages and disadvantages of living so close to town, and we still chose to live there. As a homeowner and a taxpayer, we feel that keeping the patios open is the right choice for the residents of Athens, the area businesses, and the future of Athens. If the city council members are still unsure of this issue, we would be happy to host all of you on our porch in one evening so you can listen to the noise level and judge for yourselves, and maybe you would see our point of view as well. Thank you.
Chris? Ms. Kim Goldsberry, I'm sorry I didn't pass it to the Planning Commission. You did send me the letter, and it was addressed to council, so I gave it to them. And they did read it into the record, I think Monday, mentioned it Monday. And I'll get one to them. Sorry about that.
Okay. Joel? Joel?
Scheckman.
Is that really? Scheckman? Okay. I can't read.
My name is Joel Scheckman. I'm the managing partner of Skipper's Bar and Grill and the Blue Gator. A lot of my comments have been mentioned already. At this time, Skipper's does have a patio. It is not in the area, but I would fear if this was to continue where the ordinance or amendments might stop, and would my patio at one point be considered for such legislation down the road. I would like to make a comment in regards to that we have the sound ordinance in place. I know it's been said, but I question if the first letter that you read is correct, that the chief at this time has stated that he cannot enforce it in a patio. How can we enforce it on a student patio in somebody's house, but we can't enforce it on a patio at a business? And where the difference lies there. I know, unfortunately, many students that I've talked to, it has been enforced at their property and not at another one. I would ask once again that, restrictions, business restrictions. Why does it always come down to the businesses that are being restricted? Businesses are constantly, being the culprits and are the ones that are being, our businesses are continuously being taken away from us. And I would like to ask, in regards to the smoking ban a number of years back, now we're restricting somebody once again that after the midnight, after 10 o'clock during the week, they can't go outside and consume a glass of wine on a patio and have a cigarette at the time. And as the consumption as the ordinance is read, consumption versus serving, I think it's something that could be looked at as well. Someone might be able to take a drink from inside, outside, as opposed to being served out on the patio. Might very well be something that could be considered. The last comment I guess I'd like to make is somewhat has been said as well. I believe once again we're reacting and we're not being proactive. We're being reactive. I hate to see if 95% of these complaints are being lodged against one business, that our council, our city would stand up and define and pass legislation because of one business. Legislation that is going to affect a lot of people, a lot of businesses, a lot of clients due to one business, and we can't deal with just the one business and the solution. I'm just curious, and maybe a comment can be made back as to if this ordinance would not usurp the state law. If state law allows me on my patio to serve alcohol to a certain time, and the state has come, evaluated my patio, said because I have a liquor license, I could serve law, where the city law then can come in and go over that state law by not allowing me to do that.
I don't know.
That would be a question for
the law director.
the law director.
Yeah. I think it would be a very interesting thing to evaluate.
Mm-hmm.
Thank you.
Okay. Joel, okay, let's see. Michael Weiser? Weiser.
Good afternoon, I'm Michael Weiser. I live at 60 Fairview, and for the past 10 years I lived at 24 Fairview. We get a considerable amount of noise up on the hill. But to single out the businesses, I think, is the wrong way to go. I think enforcement of the noise ordinance is the right thing to be doing. I think to penalize the businesses because they are being focused upon is the wrong thing. It may not be the people in the businesses. On a Friday and Saturday night, it may be the people outside waiting in line to get into a business that are making the most noise on Court Street. So I personally think that this is the wrong way to go, and this is a bad way to move legislatively. My sister wrote a letter, and I'd like to read it. I feel that I must write in opposition to the proposed ordinance to require a curfew for establishments on the north block of Court Street. If passed, patrons will be required to take their business inside. We've already gone through the times. I understand that the alleged problem is noise. The assumption appears to be that restaurants with outside seating and dining are the cause for excessive noise. If impacted listeners feel that noise has reached an excessive level, they should contact local authorities. Enforcing laws and ordinances that already exist should be the method employed to discourage and deal with excessive noise. The other issue here is that you intend to penalize businesses that have invested in wonderful outside areas for their profit and our enjoyment. Those businesses are doing a good thing. There are so many other events, venues, neighbors, etc. that cause excessive noise in this town. If patrons get loud or unruly, then it is the responsibility of the owners, management, to make sure that those patrons abide by the law, not pass a new one. If owners ignore that responsibility, then their businesses should be cited. Just this past Monday night, I and 4 of my responsible adult friends enjoyed our pizza dinner at the Courtside Courtyard. It was a gorgeous evening, and I want to be able to continue enjoying those kinds of dining experiences. Let's quit penalizing responsible business owners and law-abiding citizens and enforce the laws that are on the books. Treating responsible citizens like the lowest common denominator hooligan isn't better government. I live straight up the hill from the end of Court Street. I do not feel that an excessive amount of noise is traveling up the hill and find this effort to be frivolous waste of time. We should celebrate the folks operating good businesses in this town. Remember, we live in a college town, enforce the current laws, and deal with more pressing issues like our vanishing vehicle lanes. And I think she said that tongue-in-cheek. And that's my sister Dawn Weiser, and she lives at 33 Woodward.
Great, thank you. Josh Thomas?
Hello, I am Josh Thomas. I'm actually here today wearing a few different hats.
Sorry.
She'll get it down.
I am the chair of the Athens Uptown Business Association. I'm a member of the Athens Restaurant Association, and I'm also a local business owner on Court Street. So I'll kind of speak in those 3 terms. In terms of the Athens Uptown Business Association, this has been an issue that we have discussed briefly at our meetings. The opinion of most of our members is we don't like to see any ordinance that might discourage or hinder business in our uptown area. As one of the letters stated, we consider ourselves not I don't want to say fragile, but we are a growing area. We are constantly fighting the new developments on East State Street, the developments from Ohio University, and we need to have that type of development on Court Street to survive. It's important that we have our nighttime areas. It's important that the students want to be in our uptown area. So as for the Uptown Business Association, unfortunately, we would not like to see this passed in terms of the development, in terms of the vibrancy of the uptown area. The Restaurant Association, obviously, we also feel that we would not like to see this. Our restaurants, again, especially our locally owned restaurants, we are constantly battling to fight against the chains, and they're coming. Every year we see more and more. So we also would oppose this. As a local business owner, I have to say that unfortunately I would oppose it also just for the same reason, that it helps. I have outside tables myself. We're not open that late, but if we would want to be, we need to have that opportunity just for that. As for the development side, I can certainly understand Mr. Sillery's point. I can understand where people are worried about the development. As for outside eating and dining, it is this restaurant owner's opinion, and this mine only, I don't want to speak for everybody, that this town couldn't sustain another outside eating and drinking establishment on Stimson. And any developer, any restaurant entrepreneur that thought about putting something there would be crazy. The market is tough. It is a hard business. And right now, what student would walk all the way down there as opposed to just going on Court Street? I don't see that happening, and that's just my opinion. Also, in my personal opinion, I think it's important for the members of this group, for the members of City Council, and anybody concerned to take a nap tonight, take a nap tomorrow, and be out on Court Street at 1 a.m. Be on the end of Court Street. This is not something I normally do, but last weekend I had the opportunity. I found myself walking home as a person who just moved to South Shannon Street, was able to walk home. At 1 in the morning, I made a specific point, knowing this issue has been addressed to me many times, made a specific point of standing with my wife on the corner next to Brony's and listening, just listening. No music coming from Brony's, no music coming from Courtside. A murmur, certainly people outside, and you could hear some noise, but nothing loud. As I turned the corner, though, I walked down Carpenter, and there was a house party, loud music, people screaming over the music, people out in the yards. We also witnessed another house party on our way home where the police had to come because there was obviously something rowdy going on. It is my opinion that if you close these patios, you're going to increase those house parties, and they're going to be right in your neighborhoods, and that's something I would not want to see. I would rather see students on Court Street as opposed to in your neighborhoods at parties. On Court Street, we have bouncers. We have police that are much closer, which brings up the point of the police. We already have a understaffed, overstretched police force. How are they going to enforce this? How are they now, if we disperse all these students into house parties, the enforcement now, in my opinion, gets even worse. And are we asking our police to then also enforce every person that wants to sit outside at a table, to stop at every restaurant, Monday through Friday, Saturday and Sunday, and enforce that also? I think that's a question for the police chief, but something that should be answered. I appreciate the time.
Thank you. Chris? Roach?
Hello, my name is Chris Roach. I'm representing the Pigskin Sports Bar and Grill located at 38 North Court Street. To my
Sorry.
knowledge,
Now it's doing something I don't know what to do. It's,
Hit another button.
in the last 5 years that I've been the GM there at the Pigskin, we've never had any noise ordinance go against us because of our patio. Outdoor patios are key to many local businesses.
sorry.
The
I'll just time you from over here. Okay. Stop.
Comments here?
The idea or concept of regulating outdoor facilities will hurt downtown local small businesses. It's hard enough for small businesses these days to make it, and I feel that a regulation such as this will be detrimental to local small businesses. Thank you.
Herman Carson? Now, let me try to get this going here. Well, it doesn't have a little green button. It's just deciding not to go.
Go ahead and start. Okay. I'm here on behalf of Bronies LLC, the operator of Bronies. Common misperception apparently shared by a number of speakers is that they have been in violation of the noise ordinance. Bronies has had the police called more than once. There is a noise ordinance in effect, and they have never been found to be in violation of it. Mr. Sillery's probably right. We need planning, but this isn't planning. But I think Mr. Cornwell hits it on the head. Is this about zoning or noise? If it's about noise, it needs to be citywide, and you've already got an ordinance. Several references have been made that this doesn't do anything about house parties in the residential neighborhoods. It does not limit the vast majority of the city. As such, it becomes spot zoning, which is illegal. It's also a regulatory taking for each of these businesses that will be affected, and I would urge you to consult with Mr. Lang, because the Ohio case law, especially over the last 5 to 10 years, is very clear that to have a regulatory taking, there must be compensation, and to curtail some of these businesses, possibly to the point they're out of business, could be of serious economic consequences to this city. To have a valid regulatory taking, there have to be overriding is the term used, health and safety issues. And so far, I've not seen or heard of anybody express an overriding health or safety issue that would allow the city to place this type of regulatory zoning upon a small portion of the city. And to touch, I'm glad Mr. Scheckman, I think it was, that brought it up. I think that you should consult Mr. Lang, because for a number of these businesses, they are state permitted, state inspected, and the hours are set according to state law. And it would be the position, I think, of every permit holder that city regulations, especially when it appears to be an attempt to regulate noise through spot zoning, cannot and should not trump a valid state law. So, thank you.
Okay. Chris Demmel? This thing has decided not to work, so we'll just kind of do it by 3 minutes.
Hello.
Sorry, technology.
My name is Chris DeMel. The second letter you read was from my wife, Dr. Gonzalez, supporting outdoor dining in Athens. And I do understand there's a problem with noise, and I think the noise ordinance should be enforced and not pass a law restricting businesses not to operate after 10 o'clock. I'm an owner of a small business on Court Street. It is a struggle to have a business on Court Street. And when new businesses come into town, it helps us a lot. By passing laws like this, what you're doing is you're restricting entrepreneurs moving down to Court Street and opening businesses, because when they start a business, you didn't have this law. And if you go ahead and pass laws when they're operating, it reduces their revenue. So I support outdoor dining, and I'm hoping that you will not pass this law and enforce a noise ordinance to take care of the problem. Thank you.
Jennifer? Same.
Jennifer Simon, I'm with the Athens Area Chamber of Commerce. Also, the Athens Uptown Business Association is a member of the Chamber of Commerce. And I actually was given a letter by Paige Aloss to read on her behalf. I'm not sure if it made it to the city or not on time, so we'll make sure that that's put in. I'm going to read it verbatim and then maybe make a few comments. Dear Athens Planning Commission, I am unable to attend the Planning Commission hearing today regarding the proposed legislation to limit the hours of outdoor seating in the B2D zone, business zone. However, I wanted to state the Athens County Convention and Visitors Bureau position on this subject. The ACCVB is not in favor of limiting the outdoor seating times of businesses in the B2D zone. When it comes to the activities of visitors to Athens County, shopping and dining are the clear winners, for Court Street in particular. Almost $50 million in direct economic impact was generated by Athens County restaurants and retail shops in 2007. Limiting their opportunities to capitalize on the activities of both visitors and local residents, especially with the influx of chain and franchise restaurants and shops, could mean a downturn in business for those in the area. Decreased business means decreased tax income. Because visitors play such a strong role in our local economy, the ACCVB feels we should be looking at more opportunities to capture their dollars. The proposed legislation to limit the hours of outdoor seating is not a step in this direction. And I wholeheartedly believe that Paige has really hit the head on the nail. A couple of weeks ago, I wrote a piece on the economic impact of tourism on our local economy. And obviously the restaurants play a big part of that. And I do understand the noise portion, and I think it's been said 100 times. I mean, is it noise or is it zoning, and how do we deal with that? And it would be through enforcement. The chamber is always supportive of uptown businesses, and I actually, Chris was talking about, excuse me, before you point out, but had been talking about the European feel of outdoor seating. And I believe that some of us stay up late and enjoy having that European feel late at night, and being able to be outside and enjoy that. And there are some who are very respectful and understanding of neighbors, and there are others who other people, I should say, who don't have that same attitude. But that's a personal attitude. It's not necessarily a business promoting that particular view. So with that, I'd like to wrap up my comments and thank the Planning Commission for having a public hearing on this.
Thank you. Okay. And last but not least, Joe? You. Yes.
Mr. Sligo.
Mr. Sligo.
Joseph.
Okay. Since you weren't sworn in, I will swear, you can talk from there. Yeah, but you can talk from there. Do you affirm that you will tell the truth while today testifying? No, you can sit down if you want.
You can sit if you choose.
Yes. Do you affirm that you will tell the truth during your hearing today?
I do.
Thank you.
My name is Joseph Richard Sligo, and I live at 102 North Lancaster Street. I will time myself. Let me ask the chairperson, how much time do I have? 5 minutes, 6
3
minutes,
minutes.
7 minutes, what?
3 minutes.
3 minutes. I was here when the original noise ordinance was adopted. We had a representative from the police department, and I said to him, I was not a council member, I was nothing like that, I was just a concerned person. Is this enforceable? And he said yes. Now, I could give you an hour lecture about enforcement. I have listened carefully as much as I could. I usually do my homework better than I could today. I was delayed. I apologize for interrupting you. Now, there are two issues here, not one. There are actually three. Bronies is one, the parties in the neighborhood's another, and this ordinance here about the business is another. I don't know who the lady is. Was you the lady that wrote the letter? Is the lady here? I want to compliment her because I read it carefully and she makes some very good points. Excellent, as a matter of fact. Now, it is not true. I don't know who the gentleman was speaking up there. It is not true. There were several that said about controlling the business. You can control a business. You do it all the time. Let's take these sidewalk issues. One of the problems is that it gets too crowded when you're walking. And I've seen women with children going up and down. But let me tell you something else. The most courteous people to me, before I ever used canes, were people on Court Street that were waiting in line, were coming out of a bar. The party issue is another one. The problem is, for years, when Mayor Henrique was here, she gave a statistic. They had the noise ordinance passed. She says, how many people do you think have complained in 6 months? They gave a number. Then she said, she was going to tell you, she didn't tell you. She said, out of that many, how many do you think it was student complaining against student and townspeople against student? The vast majority were students against students. Students like to study. I do not understand why the owners can't control the noise. I disagree with Mr. Wharton at times, but he knows he can control the noise. Landlords can control the noise in apartments by writing in a lease. And about the noise, let me tell you, if I didn't have air conditioning in my house, I couldn't live on where I live years ago. But we're getting a different kind of student. I get students that go to bed at 9 o'clock. Some of them have more than one job. 2 minutes and 55 seconds. I got 5 seconds. The enforcement of the ordinance is the issue. The city complains they don't have money. Let them find the money. I'm in favor of the way they do up at that donkey place. They're the most courteous. I walk past there, they invite me to come in. I've never been in a place. I need to get a parking meter fixed to come to a meeting. I give them the money, they do it. Thank you very much. 3 minutes and 27 seconds.
May I ask a question? Joe, when you said find the money, are you talking about FAI?
Say that again, I'm sorry.
When you say find the money, are you saying fine with an D or fine with an E?
I'm saying that there usually are fees for using city right-of-way. We don't have them here.
Okay.
In addition, we have a tax on not entertainment, we have a tax on motels. You could use that.
Okay.
In
Thank you.
addition, you have a general rule that you can't disturb the peace regardless of the noise ordinance. I think the times are reasonable if we have good owners, but remember, these owners will change, and the people that are talking today may not be the same ones down the line, and it goes with the property. No, it goes with the individual. Thank you very much.
Thank you, Jesse.
Thank you. So that's the end of my list. If anybody else has anything to add? Comments?
I would like to add a comment, but I don't want to come up there. I don't want to come up there. I just want to.
Oh, we have
Well, you
to.
have to. This is a public hearing.
Public hearing.
Cindy?
Oh, really? Oh,
Yes.
well, I'll have to. No,
You can-
I want the freedom to say something on this issue, but I don't want the pressure of being on camera because I won't.
But
Well,
if-
you have to be sworn in and you have to speak on
I'm
camera.
sworn in, am I?
No, you're not sworn in. Did you swear in before?
Oh, okay, I'll swear in if I can stay back here.
No,
No,
no.
you still have to come
If you don't
forward.
want to do it, by being publicly on the television, give us a letter.
I wanted to make sure the people in Athens heard my comment, but I don't want to come up there, so. But
They
I think
won't-
I think
they
I have
won't
a
hear
different
you.
perspective to add, it's-
Well, you have to come up here. That's part
She
of the
could
public.
walk up there and turn her back on you and talk to the wall.
The mics won't
I'm
peak.
trying to help her.
I know, Joe.
I don't want to, because
Okay.
I'll fumble on camera.
Okay. So,
Anything else? Anybody
anything else? Anybody else?
I received
Okay.
an email.
Okay.
I would, you swear.
Okay.
Stephen first.
Did I swear you in?
No,
Do you affirm that you will tell the truth?
I don't.
Okay.
All I would like to see is
You
some
have
comments.
to say who you are, though.
Pardon me?
Can you say who you are and where you live?
My name is Stephen Messina. I have a business on Court Street.
Great.
All I want to say is common sense, enforce the law. It's been said, that's it. Okay.
Okay. I see that there's an email that Paula passed me there. One of the questions how would this affect the buggy businesses, the vendors,
Right.
particularly the A vendors?
Okay, that's a
They
great
serve
question.
outside all the time.
Great. If there's no more public comment, then I would call this public hearing closed. If you have other people who couldn't make it today and such that want to put in, we will discuss this at our next meeting. And I don't know if we will come to a vote on it, depending on how much discussion will be there, but I encourage people to write to the Planning Commission to put in their comments about this issue. So, thank you very much for coming.
let them clear out?
Yeah. We'll take a 2-minute clear-out break.
Is that official?
That was not on his agenda, so, okay. Oh,
Okay.
this needs to go down to, I have to be out of here before 2:30. I need to be out of here. Okay, now let's continue with the meeting.
2:30 is what I...
We have no cases? We don't have
No
any cases on the
no,
agenda?
no.
Okay.
Communications.
Communications. We have 2 communications on the agenda, the University Estates, project timeline, that's why you're here, and the Lovedoll Company, Blackburn subdivision.
Why don't you do the timeline first?
He was here, but no, okay. Oh, you mean he went out for lunch and now he's coming back? Okay. Okay. So, Lance, do you want to talk about what you're...
Okay. The 3-minute limit, or?
No, we'll give you a minute.
Okay.
Turn this stupid thing off.
Should I wait till he gets back?
I don't know,
What's now?
where Nicholas went. He went to feed his meter.
He needs to get a pass.
So, okay, maybe we can wait a minute.
He's coming.
Is he coming? He's coming. Okay.
Get it passed next time for Shaw. Tanya does, doesn't
Okay, great, thanks, Lance.
Okay, my name is Lance Rapp. I'm with University Estates, and as I've tried to do before is try to keep the lines of communication open, and I'm sure everyone's familiar with our project. We now have 26 single-family residence homes up there. We have 11 buildings of condo, 4-unit condo buildings with a clubhouse, and we're proud of what we've done so far. Of the 26 houses up there, you can't see that anybody even lives on the hill. Unfortunately, the previous owners at Route 682 had done a lot of clearing before we took over, and we will slowly try to remedy that. We've started our residential phase 2. The curbs went down last week, and now we're putting gravel down. So just a little bit of update of what we've been doing. I came to Paula, I think, probably a month ago now, with a timeline of how I saw things that need to go through the process. And one of the reasons I did that is we have a lot of firms that have come to us that want to joint venture a project with us or multifamily, that the very first question they ask is how long and how hard will it be for us to get through the system, you know, and then they want to know what are the steps and what's the timeline. So I prepared this little handout that everyone has one, but Chris, okay. And you know, the dates I put beside it just for the example of how they would fall if you started on September 18th. because of the tree commission and the disability commissions, and those people only meet once a month, so you have to time everything. And this is the way that I see our situation as we go forward on any future multifamily or anything to do with the PUD on our project. And Paula suggested that I come to the meeting and just present this, and that way we got everybody in one room to discuss it.
Great.
So that's my spiel. Paula, I don't know if you need to
Well,
add
I
anything
would
to it.
just ask whether or not you've already gotten your place on the tree commission hearing and the disabilities hearing.
No.
Okay. I would do
This
that
is
right
just
away.
an example, okay? I don't particularly have a project that I'm bringing forward right this second, okay? But I just want to know the process so that we,
Right. So this is what you see as how it would work out
Right.
time-wise once you turned in
these
an
are the steps
application,
that I would
right,
need to
that
take.
you would see,
Yeah.
right.
And
And-
if I turn them in December 15th, then I would have to readjust my
Right.
dates because the tree commission may have already met that month.
Right.
So that puts me back,
So, but you understand all the steps. I would just encourage that sometimes, because of holidays, that you have to make sure that those are put in, because if council doesn't meet, that kind of would put it back
Right.
2 weeks, sort of.
Yeah.
So,
I understand those. And just as my example here, if you use the line that says September 18th, when I turn that application fee into the code office, part of our responsibility when we turn that in is, I don't know who it would be, Paula, I guess now, you sit down, you go through that application to make sure that you have everything that's required, or the code department, I guess, somebody.
Right.
So that's the first step, and when you do that, that kind of sets the stage, in my opinion, on how you go through the process. Because you're going to say, all right, we got 2 weeks to review it, and then it goes to the planning commission, and,
right.
you know.
But with the planning commission, we know what we need. So if we, according to what we see as the requirements. However, the tree commission, you may go in front of the tree commission with your plans, and they may say, oh, you need, you don't have this and this, so could you please provide it? It'd be good to, do you understand? We can't talk for the other commissions.
Right.
So that's always something to, sometimes.
And both, I've been before them quite a few times, and both of them are very helpful. And it's usually, it's not so much a hearing as it is a work session.
Right.
And you work. And the disabilities, a lot of the buildings, public buildings are mandated by the state, so you're pretty well covered before you go into those meetings.
Another question I have, Lance, is when you say November 6th, public hearing if needed by Planning Commission, and then you start through the council committee, then you've got another public hearing. It's my understanding they would want to post any public hearing for 30 days, similar to what we did here today.
Right. There are certain requirements for 30 days. I think certain ones might, it's 30 like business days for some of them, so.
I don't know if I misread that or not, but I thought it was 14 days.
I think it
But
depends on what it's
I realize there is a
concerned.
period.
Right,
Okay.
right. So that's something that you may.
But on some of the things that I've been through in the past, and at the planning commission stage, they've chose to waive the public hearing because at the next council meeting, they follow right up with a public hearing. So it's kind of repetitious on sometimes we didn't, so,
Right. It kind of depends on how big the proposal is and
what the
how
proposal is and what all is
controversial.
involved in it.
Right.
Some
So-
things are more cut and dry than
Right.
other things. And I realize on the public hearing, and especially I put the public hearing and the first reading of council together too, that may or may not happen that way. But I'm just trying to get, in the ballpark, so when I talk to these people, I can say, if the world was perfect, this would be the schedule.
Right.
Okay? Now, if we have any questions or we need more support documents, the third step could end up taking 2 more weeks than we thought. But I just thought it was good if I came just so we know that this is the timeline that we need to follow.
Well, I think communication is really important between, especially large projects like yours, to make sure the lines of communication are definitely going both ways. Is there, Paul?
Wellhead protection, would that be another step involved in this, or is that be part of the technical review, or?
That, Paul, if I understand the wellhead protection, if you're building in the wellhead protection, then obviously that's part of it. I looked at these the multifamily projects that I had in mind are all on the ridge. If we do something down, per se on Armitage Road or the Golf Villas or something,
Okay. So
obviously
you have
that-
a location in mind. You have locations in mind.
yeah, that kicks in.
Okay.
One thing about something like this is that it shouldn't be construed as something legally binding between us either. I mean, we understand, that later if it comes up that the public hearing, that something is really controversial, and we have so many people at a public hearing, we have to put it over to another public hearing. We don't want that to be construed as us, going against something that's, that you see as set in stone.
Right.
Does that, okay.
I understand that, and that tells me probably we shouldn't have been doing it. It might not have been a good idea, or we didn't inform you
Right.
and give you enough details to make a decision. So, that kind of stuff I will explain to anybody that I'm working with, and that was part of the agreement we have with the city, that there's steps in there that we follow about communication, and I think it's 4 or 5 steps that we go through the city that's not even part of this, so. And with the changeover of the administration and completely, new faces, we have no complaints because we've been communicating very well, and especially the workers that come out and inspect and all that. So those aren't issues.
Okay.
I'm just trying to help myself present to a prospective
Right.
investor or something.
I personally don't see anything way out of line here. I mean, it seems reasonable, and, Paul, you seem...
Same thing, it looks like a 3-month time frame, kind of a window. I do get a little concerned that some of these different commissions do get full. They're booking for October now, but as long as you keep that in mind.
Right.
Okay, great.
Okay?
Okay, thank you.
All right, thanks for letting me speak.
Okay. The next communication is from T.H. Lovedoll and Company.
Do I need to officially be sworn in?
Did you not get sworn in either?
I missed
Okay.
the early
Do
ceremony.
you affirm that you will tell the truth while you are talking today?
Yes, I do.
Thank you.
Do you have copies of the subdivision plat there? Okay.
Who should, yes?
No, this one. That's another one.
My name is Tom Lovedoll. I'm the owner and developer of the Blackburn Woods subdivision. And I think, as you know, we completed that subdivision a couple of years ago. And at the time we came up with the original plans, we were asked to show how any adjoining lands might be considered in the future. And if you look on the plat there, there's a large section, I guess to the right or the bottom of the map, depending which way it's oriented, that just says future development. And we looked at several options of that. At one time, we were going to bring in a road from Kate Shagnow's property. Another time, we were going to bring in a road from our Larson's Lane on Blackburn Woods. And the more we've looked into it, the less feasible that is. It's pretty expensive to build that kind of infrastructure nowadays. And also, it's pretty disruptive to the area. It's a nice wooded area, and we want to really maintain it as best we can in its present state. So our present plans really would involve splitting that 12 acres into 2 fairly large lots. They would be split along a natural ravine. The acreage I've guesstimated there, but one in the 5 or 6 acre size and the other in the 6 or 7 acre size. And I talked to Paul Loge a little bit about that, and he said perhaps, my best, opportunity would be to talk to you a little bit about it, and particularly about the way to proceed. One, I think I would like to get from you whether you're, amenable to this basic concept of splitting that acreage into 2 lots. And then secondly, would be the actual direction that the split would take, whether in one sense, it's treated as just a lot split with a variance on the one lot that doesn't have road frontage, or whether this has to be a full formal amendment of the plat. And that's, my purpose of being here today. I'd like to kind of get your thinking on those points.
What's the access for these?
The access,
Yeah.
per-
One has road frontage.
yeah, one has road frontage. In the subdivision, when it was originally platted, we platted a 30-foot easement that serves both a lift station, and it also serves future access to the 12 acres that are undeveloped. And that's clearly spelled out in the deed restrictions. All the buyers of lots in the subdivision know that that lane may ultimately be used for an access. And I think it says in the deed restrictions for 3 to 4 homes. And it says also in the deed restrictions that the homeowners are aware of that it may be for Phase 2 of the Blackburn Woods subdivision, or it simply may be for other development. So that's, I think, if we took this as the lot split with the variance, it would just fall into that other development realm.
Paul Logue, did you not supply something additionally to this that we had Ron Lucas of the Street Department look at in terms of line of sight? What was he looking at?
I believe Ron looked at the line of sight for Lot A, for a driveway.
And found no issues with
He
that?
found no issues with it. I don't think that communication is included in the package.
But there's nothing else submitted from Mr. Lovedahl? There was not the actual proposal showing the sketch with the roadway?
No.
Okay.
Do you need me to come up and clarify that, where the access would be?
No, I've had our street department look at that, and they indicated there were no issues on line of sight in order to.
They called
There are
me.
some issues on Blackburn Hill Road, but this did not seem to be any conflict, so we do have that response.
That's correct. The guy from the street department, Ron, also called me just to be clear where the actual access point would be, and said that there would not be an issue with it.
So basically, you're asking us whether it should be a go ahead with amending your original plat or doing a lot split.
Correct.
What do
I
people
know,
think?
I know that Harry has some experience with this. I know under the county planning commission, they did have kind of an expedited amendment to an existing platted subdivision process.
Yeah, I mean, I think that as it stands now, you don't really have very many outstanding issues except for the one variance. And so trying to find something that's the simplest, most simplistic way of doing it would make sense for you. And
Yeah,
so-
that was my thinking.
Right.
I guess, of
So-
course, that was my thinking.
Well, and the question is, which one would be the least painful?
Well, my concern is, can you remove, if this is the platted subdivision that shows Lot A and Lot B, can you then actually remove that
Well,
and do
that
the
Lot A
modification?
and Lot B is just my
Oh, you
notation
wrote
on
that
there.
on
That's
there.
not on the original plat. The original plat simply just shows the raw extra acreage.
But it was included in part of the plan. It was just future
future
development,
development.
part of the
It
plan.
just included as a reference, yes.
It would seem that amending the plat would be more, what do you think?
And this easement is mostly a utility easement when it was put together, right?
It's currently a utility easement used for the lift station, but there's language in the deed restriction that clearly show its intention is for access to lots in that lower 12-acre section.
It seems that which one would have, if you did a lot split, would that entail more surveying?
Well, I think either way, there will be, the same basic amount of surveying. And I guess, if the plat were amended, the question I have, is how much detail we would have to get into, whether the survey would be sufficient, or, for example, like with the original subdivision, there were reams and reams of engineers' documents, topo maps, all that kind of stuff,
Well, I think what I'm talking about is, and Harry, correct me or weigh in here, Well, you do have to go through the Mylar process and amend, the sheet, but then it would just say the amendments and showing what you're doing on what you're calling Lot A and Lot B. I'm a little concerned if you pull these out, if we view it as a minor division of land and all of a sudden it's just been separated from what was originally platted as part of the subdivision. We have a surveyor here. Maybe not yours, but but I think Jerry might have done it for that one if he remembers.
I would almost agree it has to be part of the subdivision, an amendment to the subdivision. Mostly, a couple reasons. The foremost being is that really the easement, the ingress and egress to this Lot B is part of the previous subdivision. So it is going to impact that subdivision.
And then all the paperwork and all the stuff has already been, it's already going with that plat about that easement. So that would make most.
So just a simple survey to delineate the two properties, and
It would
and
have
then
to,
we-
yeah.
And then would we need a variance for the lot then, or not, the interior lot?
Probably so. Technically, it doesn't have frontage, does it?
Correct.
Okay. So it's
Okay.
not really a legal lot without frontage, I believe.
Okay. But we were saying we wouldn't really need the extra volumes of engineers' documents and stuff like that. The original set would
Right.
suffice here.
I think, because it's already been identified as future development, it's just that now you've made your choice of what that
Okay.
future development is. Does that seem logical?
I guess what you're saying is like it's not going through a preliminary plan review process. I still think you'll need your soils and everything else already, for the buildable site.
Need the soils.
I don't mean redoing your soils, but maybe getting a report from the Soil and Water Conservation District. Just have everything aligned in terms of the sewer system and all that.
It has public sewers available
Okay,
to
good
it, both
enough.
lots do.
Good.
Yeah, okay.
That's our public sewer.
Okay.
That's what the utility
Dennis
is.
thinks about.
Does that make sense? To have an amend it to the amending process?
Okay.
I just have one concern with this lot number 13 that has the easement, 30-foot easement going through it. Would we amend that so it's no longer an easement and so that it's a road?
Well, it wouldn't be a road. It would
wouldn't
really
be a
just be a
public road.
driveway.
Right.
Yeah.
Okay, it'd just be a driveway that would
Yeah.
serve two lots, though?
Yeah. Well, it would just, one lot would be served from North Blackburn Road.
Okay.
All this road would serve, or this
It was
lane would
just the
serve
lot
would be
B.
the utility station in the lot, yeah.
Okay.
Yeah.
It's a flight lot.
It appears to become an easement and a driveway
Yeah,
sometimes.
yeah, well, I mean, lot 13 kind of, it's still within their property, but it's an easement of right-of-way, so that's my only concern. But if it's already been part of the,
Okay.
part of the deed to begin with, I guess they already understand that.
Okay.
Any other questions? Comments?
No.
Okay.
Okay, thanks very much.
Thank you.
Bye.
Okey-dokey. Now,
We consider this a addition to the plan.
amendment.
Amendment
to
to
the-
a final
Yes.
plan. We need all the signatures of the council.
No, I'm concerned about bringing this up today.
For this preliminary, we need to put it on the agenda then.
Yes, it didn't get put on the agenda.
Okay, I move that we put the proposed minor lot split minor subdivision, I guess, of, what is this called?
It is the Stone Hill subdivision.
Stone Hill subdivision on the agenda as a communication.
Do I have a second? Okay. All in favor?
Aye.
Okay.
Okay. I say it just came in day before.
Yeah, one problem with this is that it just came in on Monday, and usually we like to have these things a week ahead of time, so that because if it comes in on Monday, it's not going to get to the commission members. Like, this is the first time we've seen it. Okay. So, why don't you present what your idea is, and if we have any kind of general questions, but we will put you back on the agenda.
Once you understand why I'm here, then
Can you,
some of that might be.
okay. And can I swear you in? I can swear all these people in. Do you affirm that you will tell the truth today?
I do.
Thank you. State who you are and where you live, please.
My name is Gerald Behe, Jerry Behe, surveyor,
And I want to correct one statement that was made earlier. This is not Stonehill subdivision. This was what was going to be Stonehill subdivision way back, okay?
Do you have a name for it
This is the
then?
residual, no, sir, not at this point. This is the residual acreage of what was once going to be Stonehill subdivision. Now, I'm here today to present a conceptual plan, if you will, for this, and to get a read on what the Planning Commission's thoughts are, all right? What we've done here is, and all of you, I believe, have a copy of the map that you can refer to. The only part of Stonehill that was developed was what is referred to as Phase 1, which consisted of 7 lots, all right, down in the left-hand side of the plat, coming in off of Shady Lane. And as I'm sure many of you are aware of, there were numerous and many problems with regard to the development and the road and the bond and all that, all those issues. But the Citizens Bank now owns and has owned the residual acreage of this property, which comprises all of, on your map, Tract 1, Parcel 2, 3, 4, and the residual parcel tract of number 5. Now, my purpose in coming to the Planning Commission is twofold. To find out, again, what the general consensus is with regard to what we're proposing to do with this. What I'm would be asking for is a variance for a private ingress-egress easement. We would be dividing this entire acreage into 5 pieces, counting the residual, which is allowed under the minor subdivision, but it does require a variance for the new ingress-egress easement. This will not be a public roadway. There will be a very detailed maintenance agreement executed on each and every deed, as well as on the final plat of survey that you have a copy of as well. This is the same maintenance agreement that I was before your body about a year ago, actually, on a development out on Fisher Road. Now, there aren't, other than Harry's face, I think might be the only one that might have been here at that time. And at that time, it was a little different situation, but basically the same, a much longer driveway that was involved. We want to find out if this is going to be something that the Planning Commission would entertain, granting a variance for the private driveway before we proceed to actually doing all the final surveying and so forth. I was the original surveyor on Stonehill subdivision. That's why this map has a lot more information on it perhaps than you're used to seeing at this particular point in the process, because I have those files and had all the topo and so forth, and thought that that might be helpful for you all to see, even though on a minor subdivision topo is not required. The lots would be sewered by the Plains Water and Sewer District, and sewer is available, and there's no problem with getting into it. The owner of the property, of course, would have to put in the sewer, and it would have to go through the EPA sewer approval process and all of that for any public systems. So I guess, and I apologize that this wasn't gotten to you the full week in advance. I'm sorry for that, but I just wasn't able to get it completed in time for that. We are proposing the commercial area is actually an area as you come in on Shady Lane that's at the bottom of the hill on the left-hand side, that actually some foundations and so forth were started in that area subsequent to the development of the first phase of Stonehill. And nothing is anticipated being done with that now, but we want to go ahead and, if you will, fully subdivide the site so that you know as a planning commission what our intention is to do with this site. And then should anyone else in the future desire to do anything else, of course, they would have to come back and redo the whole process. But that site would be held for perhaps commercial development in the future.
The three other lots, parcel 2, parcel 3, and parcel 4, on the left-hand side of your map, on the left-hand side of the easement, are approximately 1.7 acres each, so they'll be very nice sized lots. That's a wooded area. It's a very, very attractive area that would be residential housing, single-family residential housing. And the residual tract is, at this point, is anticipated. One house is going to be built on it, and the person who is interested in the property will occupy that house. And he will have a 60.8 acre tract overlooking Athens, basically, what it boils down to.
Jerry, is Shady
Yes,
Lane
Paul.
already accepted as a public street?
Yes, the up to where my word easement
Begins
ends is where the public street, yes, it has been accepted and so forth, and with all the hassles with the township and the county and all that, there's actually been some paving done out there, not in the very recent past, to kind of help that road out a little bit.
That Shady Lane, then the public roadway would serve the future parcel, what you call Tract 1, and the residue tract?
Correct, yes. Shady Lane is developed all the way back in, and there is presently access off of Shady Lane into that commercial or potential commercial area. That area was extensively filled a number of years ago, many years ago. Actually, when I started reviewing my files, this was 11 years ago I started out on this job, so this project. So at any rate, that's, if you have any questions, I will answer them to the best of my ability, but I would like to try to walk away today with at least a feel that if now I know the normal process in the past anyway, and I assume it'll be the same now, is that I would prepare the plat of survey, I would submit it to the code office. The code office would deny it because it requires a variance for the private ingress egress easement. We would then be before the Planning Commission with our final survey drawing, and then hopefully get approval at that time, and then go before City Council just as the process last year.
So the variance is because you can't have more than how many lots on an easement, I guess? Is that really the requirement? Why?
No.
Why is the variance?
The variance is
why do you require
because there is no public road frontage that serves parcels 2, 3, and 4.
Okay.
Okay, there is public road frontage that serves Tract 1 and the residual Tract 5, but no public road frontage. So
it's for the tracks 2, 3, and 4. And how come you don't want to provide that road and make it a public road?
Well, to be perfectly frank with you, the development costs are very high, number one. Number two, the desire is to keep this a low traveled situation, to make it, which will actually enhance the value of those three parcels of property. The maintenance agreement that I actually came up with this a couple of years ago, and Bob Eichenberg and I worked on it together a few years back, actually. And then it's a pretty tight maintenance agreement, and it's put in each and every deed. So it's not a case of where somebody has to refer to a survey plat that's on file somewhere or what have you to be aware of it. And, you know, the potential always exists, and that's another reason we've provided 50-foot of right-of-way, or would provide 50-foot of right-of-way. The potential exists for development in the future, and there at least will have been sufficient right-of-way to allow for that. And the sewer and the water, of course, would be taken further back into the site as a result of this whole thing as well.
And back to the buildable lots issue.
Okay.
Buildable lots, meaning that these can sustain single-family homes.
Sure. And?
Whether or not you have, you know, have you gone through any review with the Soil and Water Conservation District, or?
No.
Look at it?
At this point, as I said earlier, at this point, I'm here to get a read from you all before we go further. You know, this is, way more information than you're used to seeing at this point in the process. And a lot of these things would, if it were a full-fledged subdivision, this would go in front of the technical review committee and so forth. But given the fact that it's a quote-unquote minor subdivision, and there's only one variance involved, then I wanted to come here first because there's a potential deal with the Citizens Bank that owns this property. Citizens Bank is not in the property development business for someone to purchase this property if this type of thing can happen. That's the whole purpose behind this. We would take the appropriate steps. If I walk out of here today and you tell me yes, given whatever X, Y, and Z, then we would entertain approving this as a minor subdivision. Then we will proceed and take the appropriate steps. We haven't started on sewer plans or water plans or any of those kinds of things until we get a read from all of you as to what your thoughts are. And we know that, you know, there was a lot of, I won't say bad blood, but there was certainly a lot of controversy regarding the Shady Lane and Sandstone Court with regard to the bond and the construction of the roads and the county and the township and the city and all that. So I wanted to come before you and show you what our overall plan was and what we would like to do, and then leave here with some sense of direction, if you will.
Well, you have a question? Comments? So he wants a reading of the council. The reading of the commission. So.
Go ahead.
No. Paul?
No, I'm still thinking.
Still thinking. Paul? Yeah. Any concerns that jump right out?
I already stated mine.
Okay.
But it
Well,
sounds like
we
if we said to you, we like this concept, go forth, you would come back with the information.
Yes, I would come back with whatever. Normally in a minor subdivision, there isn't much information required other than the plat of survey and the appropriate driveway agreement and that type of thing. And the fact that it's going to be served by public sewer, then all of those other issues disappear with regard to the health department and so forth. But if you tell me that today that you want to see something from Soil and Water that says that our configuration is a reason that it can be built upon, we don't have any problem with doing that. And also be aware that the final document that I bring into you might look a little bit different than this, because Paula knows me from the past in terms of my surveying and so forth, and I like to divide land up that makes sense and makes use of the land to a reasonable degree. So when I actually get out there and I'm doing the field work, if I find it's necessary to move the road up the hill a little bit or you know, shift this or shift that, you'll get something back in here as a final document that resembles this, but it may not be this exactly. But it will be 3 individual lots to be built upon. It will be the commercial tract for potential future development, so that tract can be on record as a lot of record, if you will, and the residual tract will be a single large tract. So that's what I would come back in front of you with, and whatever you tell me that you need within reason to make that happen, we'll certainly be happy to comply with.
I think one thing is that I don't think the commission feels I don't feel comfortable saying, well, I think you're going to need this, 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 and this at this point, because we've just started. From my reading, this sounds reasonable. I think the reality of the bad blood, I'm certainly happy that you are taking that into consideration with all the problems with the road, and that you are addressing that right up front, I think is really important. So that's my take on it. Paul?
I guess my only concern is the residual tract portion. If it gets divided in the future to more pieces, basically the reason why it's a minor subdivision is because that residual tract, all 60 acres, has not been divided and parceled anymore. If I understand how subdivision regs work. My concern is the fact that we do this minor subdivision and the residual tract comes back 2 years from now and says, let's cut it up some more. at that point, when I look at this, I'd almost start saying, okay, we want to restrict any more division of this residual tract, which I don't think is fair. At the same time, an easement between, at this point, 4 different property owners or more in the future could be a concern of mine. So that's part of my concern of what's happening here. We're looking at, the requirement just so it falls under the minor subdivision rates rather than anything else. And that's partially because we don't want to build a road and we have so many lots, if I understand it correctly. So I'm a little bit leery of the action here. But I wouldn't mind hearing more. And again, I'm cognizant of the history of Shady Lane. I think it cost the city something in the past, and it cost county engineers or county commissioners a little in the past.
Right.
And then it comes down to the enforceable nature of an easement agreement of this nature that would go through small claims court to get the road fixed. And those are my concerns, really.
I can't speak at this point right now today, but my feeling is that there probably would not be any reluctance on the part of the potential purchaser to say that in the foreseeable future, I mean, that the residual tract is not going to be divided into additional pieces. To forever preclude something like that is rather ludicrous, I believe. I mean, you can't. None of us know what the economy or what our world is going to look like 20 or 30 years from now. But certainly the intent of the person who is interested in buying this now is not to divide this further. He wants that piece of land for himself. And should any other division occur within this property, it would have to come before this board anyway, in the future. And, to have some sort of reasonable agreement to enter into for this current transaction as far as the further dividing, we would certainly be amenable to considering something like that. I don't know exactly how that would happen or how it could be worded or what have you, but that's really a very, I'm just not sure how that could be dealt with exactly.
And that's part of my concern. Again, I look and say, okay, I would say offhand if I was going to try fixing something like that, and so, in other words, make sure that we didn't have further subdivisions, another series of minor subdivisions on the 60 acres, where at that point some requirement of that easement ceasing to be an easement but a public road would fall into play. Then that brings up this point, the standard of the road the standard of the private road or the easement that's being built now. If we say, okay, in the future, 10 years in the future, somebody cuts up the track 5, at that point it trips a wire where you have to make that a public road, and therefore it trips a wire that has to be built up to a certain standard.
There would be no objection to that at all, I don't believe. I can't, say 100%, but that certainly is reasonable, and that was the thought all along in doing this and in providing 50 foot of right-of-way, that should the future, change things and that want to be made a public access, then it could be. That option exists.
Okay, and I'm aware the minimum roadway surface is a minimum of 10 feet, even though the right-of-way is 50, so.
I'm sorry?
According to your easement document, maintenance agreement, the roadway would be a minimum of 10 feet. The road actual paved, or rather roadway surface, I think is the term here.
Roadway surface, 10 feet across. It's a driveway. But there's sufficient right-of-way, and there would be, even with that 10-foot driveway, there would be proper ditching and so forth, and there would be some culverts under the road. But should any public development be done, then it would have to be brought up to whatever public standards were in effect at that time, and there'd be sufficient right-of-way there for that to occur. Basically the 10-foot driveway would be of no consequence to developing a future public road. You'd have some base in place, but that would be about it.
Okay, and the last question I have is, you said the same as Fisher Road, an easement same as Fisher Road, and we're new faces here. So tell us how the Fisher Road
The Fisher Road property was, it's terrible, I can't even think of his name, Dr. Clark. I was before this body for Dr. Clark. He and his wife own acres on Fisher Road, and we were dividing off, basically cutting the acreage in half, but it did not have public road frontage. And we used this exact maintenance agreement right here, and it was a private driveway, just exactly like this, only instead of 5 pieces total, which is what you can have as a minor subdivision, including a residual, there were 2 pieces total. So,
And that was okay? That passed?
yes.
It's working out?
Oh, yeah.
Okay.
Yes.
So I think that the general consensus is given our concerns. Is that right?
I'd like to hear from Harry or
Harry?
Nicholas.
No, looks, haven't looked at it the first time.
Right.
Looks okay.
Again, I'm going to go back to what I stated with T.H. Lovedoll, is that, my concern is this private ingress, egress thing. They work up till a time, and, Mayor mentioned how, eventually these things sometimes get taken to small claims court because someone's not going to be willing to maintain the roadway. And, granted, it's part of the deed, and sure, there's law and that sort of thing, but, we had a meeting earlier today concerning a noise ordinance, and that's also law, and people aren't willing to enforce it and not enforce it. So, public roadways work. I think maybe right now, we can't really rule on this. It's really just stating how we feel, what's going on. But that's my main concern is the private right of way. And I understand you've talked with Bob Eichenberg about drawing that up. So you've done some thinking about it. But, again, when you're going back and doing the survey, you might start to realize that might work better as a public roadway. So that's all I really need to say.
Nicholas, there have been a lot of these with these private access easements out in the county because we're running out of road frontage.
Right.
But I don't, I'm just generally. But I would ask you, Jerry, to talk with Bob and get the most recent update of this. Make sure that the 10 feet width minimum service would service all the emergency vehicles. Might have to get down there. And I know that he's also included now a mediation clause, so they would also utilize the Athens County Mediation Council.
Well, we certainly, yeah, I have a good working relationship with Bob, and I would be happy to do that. Whatever whatever the county and the city feel comfortable with in terms of the maintenance agreement, we would be happy to do that.
Okay. Any other questions, concerns? Okay. Does that give you some guidance?
Yes.
Okay.
Thank you very much for your time.
No problem. Okay. Next is the report from the city planner. Make it quick.
3 minutes.
I'll keep this brief out of respect for our citizen members of our commission today, since it's running so late already. Just a few, 2 basic things. One is that the GIS zoning map looks like it's in its final draft. One small change needs to be made. I'm communicating with Ilgard over that. And then it's a decision as to, there's nothing in our code that guides us with how we approve the official zoning map. It just says, I believe it needs to be affirmed by attested, yes, attested. But it doesn't say by who, and Ohio Revised Code doesn't give any guidance either. So you could interpret it as the Planning Commission, the zoning administrator, the mayor, or city council, all 4 of them or a few of them. So the mayor and I discussed this morning, and it is something we may want to look for guidance from the law director. Other than that, Commissioner Fall and I attended a meeting 2 weeks ago up in Columbus on how to integrate sustainability into our city code. I was hoping to have more information on that for you today, but with my last 2 weeks being trading back and forth between planning and the code office, I haven't had the time to put anything together for you today, but I will be working for that for the next planning commission meeting. So it was a very, very informative, very interesting day of education.
Okay. Thank you.
Thank you.
That is all.
Okay, opportunity for citizens to speak.
Does not look like it, does it?
Okay. Announcements and other business, next meeting.
Okay, this is something that has to be brought up.
Yes, we need to move the meetings, because I teach at 1. I'm late.
And-
Tuesday, Thursdays are really bad right now, so
And,
Monday, Wednesdays.
Okay, and I will not be available for the third Thursdays for the next year.
Okay, well, we can change it to earlier on Thursdays.
But you're gone all Thursdays?
No, all
Third.
morning, actually.
Oh, it would be.
We run it later.
So,
It's actually, I said, my third Thursday is going to be tied up
right,
in the morning,
Right.
at least till,
okay.
so we
So
could move it.
Tuesdays or Monday, Wednesday?
I thought you said you had bad Tuesdays.
Well, if I was out by 1, that's, if we started at 11, I think it'd be better Monday, Wednesday. What sort of?
What do you say?
I'm open.
Okay. You have something on Thursday anyway.
Well, I may have a county
Oh,
planning commission meeting early on a Thursday, about the third Thursday, right?
That's the AM.
Yeah, that's
Thursday.
the AM, yeah.
Regional Planning Commission.
That's right.
Well, what about Monday, Wednesday?
How's your Mondays and Wednesdays?
Well, at noon I have Rotary
On Monday?
on Monday.
So Wednesday? Wednesday?
No, Wednesday, well, actually Wednesday for us, well, I guess I could move my press conference on Wednesday. It's usually at 1:30 here.
Oh.
We meld right into
What
it.
time? Are we sticking with this noon?
Yeah. Would that?
Does
or-
that work for you?
I mean, I can go
That's
earlier in the
okay,
morning.
except that,
11 would also function. I just can't go later, because then it just starts running into 3 o'clock, and then I have a hard time getting my kids. So,
start earlier.
Do you miss a lunch if we do keep the noon on Wednesdays?
No, Wednesday.
Okay.
Would be free.
So we do Wednesdays at noon?
Yeah. Do you need to do it at 11 on Wednesday, or is noon
no,
fine?
noon's
Okay.
fine. It's just,
You have to teach at 1 now?
no, only Tuesdays, Thursdays.
All right.
Oh.
Okay, so we're talking about what now?
Wednesday
Wednesday
at 12.
at 12, okay.
So October 1st?
When would our next meeting be? Yeah, it would just be the Wednesday before. So does that, and this is what we can do, that's just changing it for, because I think the class I'll be teaching will be on Tuesday, Thursdays for a while. I'll tell them
Okay,
that.
that's for the next one. Do you want to set up something permanent, or you just
I
want?
thought we were going to
This
stick
is,
with
I think this would
Wednesdays.
be permanent. Do you think so?
Okay, so it's
Okay.
at, we're talking about the first and third Wednesday
Days.
of the month. Okay.
Okay.
I will probably alter my
No?
press conference for that reason.
Oh.
Okay.
No? Well, they'll just hang around. Either it starts at 1:30 or maybe it starts at 2.
We could probably move that. What's at noon on Tuesdays?
You guys don't have anything else
Why
to do?
wouldn't you just do it right after planning commission?
Yeah, that would be fun. I have no problem with that. I can do that.
Okay.
But that varies on time, though. You look and say, okay, it's 2 o'clock now, might be 1.
It's rare that it would be 2, you know?
You never know.
Holds people in suspense, I guess.
Okay, so October 1st is the next meeting, 12 noon,
12 noon.
Wednesday.
Okay.
Okay. The other thing, of course, is you're interim chair now. Do we want to do nominations for since everybody's here, I wanted to wait till everybody's here.
Especially me.
Well, you, Harry, Nicholas, mostly because I don't feel it's my, I don't think it's proper for me or any of the city officials to actually nominate the chair. Okay?
I nominate Chris.
I do feel I can second that if that's the case. Unless, you have any other nominations, I guess is the question. All in favor then? You're supposed to be saying this, Ms. Chair.
Oh, all in favor. Sorry. Well, that seems kind of tacky for me to talk about my own nomination. All those in favor?
Aye.
Do we want to have an interim chair appointed as well, just in case?
Oh, like a vice chair?
A vice chair, yeah.
Okay.
Well, since you were doing that already as a vice chair.
Yeah, but I nominate Harry as a vice chair.
I second the nomination.
All those in favor?
Aye.
Aye.
Okay, there you go, Harry.
Okay. Disposition of the minutes. How's the minutes?
The minutes were very brief.
Brief minutes.
Yes.
Minute minutes.
I move we accept the minutes.
Second? Okay, all those in favor?
Aye.
And I submit that we adjourn. All
Second.
those in favor?
Yes.
Second of all, you need.
Okay, thank you. Thanks for your
Okay,
comment.
thank you.
And Nicholas, you're going to...